Hola, buen día. Les estamos dando la bienvenida a este cuarto día de ponencias del ciclo de ponencias remotas para la capacitación del Tratado de Libre Comercio México, Estados Unidos y Canadá, el T-MEC. Este cuarto día está dedicado a un tema muy importante, el enforcement, especialmente en lo relacionado con el tema laboral. Quizás no un tema directo de las áreas de comercio exterior, quizás ustedes piensen que este es un tema más para el área de recursos humanos o el área de relaciones laborales de la empresa. Sin embargo, un tema importantísimo es que las sanciones son vinculantes al comercio. Entonces, de existir una problemática en este sentido, ustedes, las áreas de comercio, serían las primeras afectadas y las primeras a las que seguramente los corporativos van a llamar y van a decir qué está sucediendo. Entonces, hoy es importantísimo que ustedes conozcan también los aspectos esenciales de estas disposiciones. Hoy tenemos un invitado de nuestro aliado estratégico Baker McKenzie de la ciudad de Washington, experto en estos temas. Por lo tanto, voy a presentar con mucho entusiasmo a John Foote. Él va a hacer su presentación en inglés, pero voy a leer su currículo en español para el beneficio de todos ustedes. John Foote asesora a compañías en asuntos de cumplimiento político y su aplicación con énfasis en el comercio internacional. Es orador y escribe regularmente sobre temas relacionados con políticas públicas y comercio internacional. Antes de unirse a Baker McKenzie, John fue asistente legal para el excelentísimo Gregory Carman de la Corte de Comercio Internacional de los Estados Unidos. Tiene un gran compromiso con el trabajo pro bono y John es experto en temas de enforcement, de cumplimiento de carácter obligatorio en materia de comercio internacional. John, I want to welcome you. Welcome to Index. Welcome to this important speech related to labor and the enforcement under the USMCA. We're very glad to have you here. Thank you very much for collaborating with Index today. And the audience is ready for you. We are ready to hear you talking about the enforcement under the labor aspect of the USMCA. Welcome, John.
Excellent. Thank you. So the U.S.-Mexico-Canada Free Trade Agreement, or the USMCA, is the first free trade agreement that the United States has completed, and which is entering into force on July 1st, which contains a detailed labor chapter containing a range of legal obligations on all parties with respect to labor rights. These labor rights include the obligation to recognize all ILO obligations, all basic labor rights, which include the freedom of association, which includes the right to strike. It includes freedom from violence and from threats and intimidation. It requires the parties to effectively recognize the right to collective bargaining. It requires the parties to eliminate forced and child labor and to prohibit the importation of goods made with forced and child labor. It requires the parties to eliminate employment discrimination. It also requires each party to actively and effectively enforce its own labor laws. And there have been significant changes in Mexico's labor laws pursuant to the USMCA over the course of the last 18 months. All of these labor rules are primarily enforceable between the parties to the agreement, that is, between the United States and Mexico, or between Canada and Mexico. But there are certain rules, and specifically the ones that I have highlighted in red here, which the USMCA permits a party to effectively enforce against an individual company or an individual facility in a different country. In practice, this means that the U.S. and to Canada will be enforcing labor rights obligations against facilities located in Mexico, specific facilities in Mexico. Technically, these agreements are bilateral, meaning that they apply to Mexico and to the United States equally. However, there are caveats and exceptions, which mean that these rules have a limited application against the United States. There are only a certain type of order that are enforceable against the United States by the government of Mexico. But today, given this audience, I'm going to be describing and discussing the enforcement of labor rules against facilities located in Mexico, because the consequence for or resulting from, or potential penalty resulting from an enforcement action relates to trade benefits afforded to that specific facility in Mexico. Next slide, please. So enforcing rules, as I said, most of the labor rules are enforceable. All of the labor rules are enforceable between the parties, that is, between the United States government and the government of Mexico. However, the USMCA contains the first of its kind enforcement mechanism in any trade agreement, which will allow a party, such as the United States, to address a denial of specific kinds of labor rights at a specific facility, such as a factory, located in Mexico. This is known in the agreement as a facility-specific rapid response labor mechanism, or RRLM for short. A denial of rights in this instance is limited to a violation of the two freedoms that are specifically highlighted here in red: the freedom of association and the right to collective bargaining. And a covered facility is the type of facility in Mexico that could be subject to this type of enforcement. It means a facility working in a priority sector in Mexico, which either produces goods or supplies services that are traded between the parties. That is to say, produces goods that are sold into the United States or traded to the United States, or that competes with goods or services of another party. So if you were a facility in a priority sector manufacturing goods in Mexico for sale exclusively in Mexico, you could nevertheless be a covered facility targeted here by this rapid response labor mechanism if you are competing in the Mexico market against US manufactured goods. So the universe of facilities that are potentially subject to this enforcement mechanism would include facilities manufacturing, such as maquiladoras, manufacturing goods that are destined for the United States, but also Mexico facilities that are manufacturing goods sold in Mexico and competing with US manufactured products. Next slide. So the priority sectors are defined for purposes of the RRLM as including any sector involved in the production, any facility involved in the production of manufactured goods, any facility involved in supplying services, or any facility involved in mining. And manufactured goods are specifically identified as including a selection of industries which are the priority focus for the initial enforcement. So any Mexico factory that is involved in the production of aerospace products and components, automobiles or automotive parts, cosmetic products, industrial baked goods, steel and aluminum, glass, pottery, plastic, forgings, or cement. Those are the initial priority sectors. If a Mexico facility manufactures goods that are not listed on this list, it may still be subject to the rapid response labor mechanism. However, we do expect that the initial enforcement activity will focus on these industries identified in the agreement and are set out here. Next slide, please. When the rapid response labor mechanism is invoked, it will lead to a number of trade consequences for the Mexico facility involved. The immediate penalty which can be imposed is a delay in the final closure of U.S. customs entries. If you have familiarity with the U.S. customs entry process, you may be familiar with the term liquidation. Is when a U.S. customs entry filed with U.S. Customs is finally resolved and closed out for good. This typically happens on an automated schedule about 10 months after goods are imported into the United States. Liquidation can be suspended, which means delayed, and the entry is not finalized in the event that the rapid response labor mechanism is invoked with respect to a specific facility. The suspension of liquidation means that it will give the United States government time to decide whether additional consequences should be imposed. Question, for example, the loss of tariff benefits or penalties, or even a denial of entry. Those three additional consequences that I just mentioned are the main potential penalties from the invocation of the rapid response labor mechanism. Additionally, any facility which is targeted by the rapid response labor mechanism should expect to see labor enforcement from the Mexico authorities. And the goods, as I mentioned, could be subject to the loss of tariff benefits, meaning goods that are normally imported duty-free into the United States under NAFTA or the USMCA would potentially lose that tariff benefit. Penalties could be assessed, and in the case of repeat violations, the penalty could result in the denial of entry into the United States of goods. It's important to note that violations are tracked by corporate ownership, which means that if there are different Mexican facilities which have the same corporate parent, either in Mexico or the United States or in any country, regardless of where the corporate parent is located, those violations would be tracked according to the corporate ownership structure, which means that the results would be cumulative. So a violation against a facility might seem to that facility to be the first violation, but it might in fact be the second or third or repeat violation within the corporate ownership structure, meaning that denial of entry for goods could be at stake sooner than might be expected when the rapid response labor mechanism is invoked. Next slide, please. So I'd like to just talk very briefly about the elements required to launch the rapid response labor mechanism. How does this begin? Any party can file an allegation that workers at a covered facility in Mexico have been denied rights. Which rights? Specifically the rights to freedom of association and collective bargaining. This type of allegation could be filed by any party. There is no standing requirement. Anyone could file an allegation that workers at the Mexico facility have lost these rights. They could be filed by workers themselves at the Mexico facility. These allegations could be filed by a labor union. And in fact, we expect the majority of allegations will probably be filed by labor unions. Activists or NGOs might file allegations. You might even have instances where a competitor company files an allegation. For example, if one parent company of a Mexican facility which is unionized knows that its competitor facility has been actively suppressing union activity, you might have an allegation filed by a competitor against the entity that is denying those rights of free association or collective bargaining. And here again, I would just call out that the right to freedom of association includes the right to strike, and it also includes freedom from violence or threats or intimidation. So now I'd like to talk about what are the elements to launching the rapid response labor mechanism. So Any use of the rapid response labor mechanism would be initiated by filing an allegation, some party filing an allegation that workers at a covered facility have suffered a denial of rights that is covered by the rapid response labor mechanism. So this would be a denial of free association or collective bargaining rights. This allegation could be filed by anybody. There is no standing requirement, which means that it could be filed, for example, by workers in Mexico. It could be filed by a labor union representing workers in a particular field or industry. It could be filed by an NGO or activists. It could even be filed by a business competitor. For example, if a competitor has a Mexico facility that is unionized and it knows that its competitor facility is not unionized in Mexico, it may file an allegation that the other company is violating the right to free association or collective bargaining rights. These allegations against a Mexico facility would be filed with the U.S. government. The USMCA legislation in the United States formed the Interagency Labor Committee. It's basically the U.S. Trade Representative and the U.S. Secretary of Labor. And the Interagency Labor Committee is the group that receives the allegations and has 30 days to decide whether there is sufficient credible evidence of a denial of rights. Basically, this is what we'd call a go, no-go decision. The U.S. government will evaluate the allegations and decide whether they seem credible. Then the U.S. government has 60 days within which to decide whether or not to request a rapid response labor panel, which is a panel of independent experts comprised of representatives from the United States, Mexico, and Canada, not government representatives, but representatives selected by the governments of Mexico, Canada, and the United States to form the panel, which would result then in further proceedings by the panel. Next slide, please. I just take a moment to talk about what constitutes a denial of rights, because this rapid response labor mechanism is about the intersection of labor rights and trade remedies. At the Mexico facility, a denial of rights would be present whenever there has been a violation of freedom of association and the right to collective bargaining. This would be interpreted not just under Mexico law, but under the U.S. government's view of what these rights consist of. This could include, for example, a Mexico facility or management which interfered in concerted activities for collective bargaining by workers, or the interference with workers who are trying to organize or form or join a union of their choice. The interference in union activities, including discrimination or coercion against workers, violence or threats of violence, or the company's refusal to bargain collectively with a duly established union. Any of these activities would presumably constitute a denial of rights, which could result in trade remedies being employed under the rapid response labor mechanism. Next slide, please. So what happens if the rapid response labor mechanism is invoked? Well, the overall goal of the rapid response labor mechanism is for the United States and Mexico to agree that there has been a denial of rights and to find a solution which will minimize any interruption to trade. And the goal is, of course, to reach this type of a mediated solution even before a rapid response panel has to be formed. So once the United States makes that initial go, no-go determination, the U.S. Trade Representative will notify Mexico authorities, which will have a period of time, a relatively short period of time, about 45 days, to investigate the claim, investigate the allegation, and to attempt to remediate with the Mexico facility. So this is the Mexico government attempting to remediate the issue with the Mexico facility. The Mexican government will then be responsible for either agreeing or disagreeing with the U.S. Claim that there has been a denial of rights. Only if Mexico disagrees that there has been a denial of rights will the dispute be referred to a rapid response panel. As I mentioned, this rapid response panel is going to be comprised of representatives who are expert in the field of labor rights. And each party to the agreement have nominated or are expected to nominate individuals to sit on the rapid response panel, and there will be a selection of a small number of experts to serve on a panel for an individual case. The rapid response panel is responsible for attempting to verify whether there has been a denial of rights. That's their job. They have to figure out whether the U.S. is correct in its assertion or not that there was a denial of rights. Mexico will be asked by the panel, the government of Mexico will be asked by the panel to consent to an on-site verification at the facility. That on-site verification could be accompanied by observers from each party, from the Mexican government and from the United States government. The rapid response panel, and here is where you get to the rapid part of the rapid response panel, they have to issue a decision within 30 days. Remedies can be imposed as soon as 5 days later, and the remedies will remain in effect for at least 6 months. If the government of Mexico were to decline an on-site verification, if they were to refuse to permit the panel to visit the facility in Mexico, the rapid response panel is instructed to take that into account in reaching a conclusion about whether there has been a denial of rights. Next slide, please. So here again, I'm just going over what the penalties are that are at stake. As I mentioned, from the go, no-go determination by the U.S. government, if the U.S. finds that there is credible evidence of a violation of labor rights on the part of the facility, final resolution of the U.S. customs entries may be suspended. This is known as suspension of liquidation. And the purpose of suspending liquidation is to determine whether or not there has been a denial of rights, because a denial of rights can be remediated by a loss of preferential tariff benefits. In other words, the loss of the duty-free benefits that you would otherwise be entitled to under the USMCA. It can also result in the imposition of penalties on goods manufactured or services provided by the covered facility. We don't yet have a lot of clarity on exactly how these penalties might be imposed, what mechanism might be used to impose them, but the agreement is clear that penalties are contemplated. As I mentioned earlier, there is also a view towards tracking violations for facilities by common corporate ownership, which again means that if your facility were to be identified as being involved in a potential denial of rights, if a different facility with the common corporate parent had already been found to have engaged in a denial of rights, the remedies are expanded, potential remedies are expanded to include the denial of entry of such goods into the United States. So potentially the stakes are much higher in the instance of multiple violations within the same corporate ownership structure. Next slide, please. So here I just want to note that the rapid response labor mechanism, while initially only applying to violations for freedom of association or the right to collective bargaining, there is a provision within the agreement which would allow this rapid response labor mechanism to be expanded to include other violations of labor obligations. And if you remember at the outset of my presentation, I explained that there is a comprehensive labor chapter, including a whole range of labor obligations, including, in addition to freedom of association and right to collective bargaining, the elimination of forced and child labor, elimination of employment discrimination, and the effective enforcement of each party's own labor laws. That is significant because an allegation that the United States might make, for example, if it believes that Mexico is not effectively enforcing its own labor laws, the United States could initiate a state-to-state dispute with Mexico on that grounds. The USMCA calls out all of the following as responsibilities of Mexico with respect to the enforcement of its own labor laws. Things such as appointing and training inspectors, investigating suspected violations, including using unannounced on-site inspections, and giving due consideration to requests to investigate a facility for violating labor laws, requiring record keeping, encouraging labor management committees to be established, encouraging mediation or conciliation and arbitration of labor disputes, initiating sanctions or remedies for violations of labor laws, or implementing remedies and sanctions for noncompliance of labor laws. All of those are examples of obligations that Mexico has to enforce its own labor laws, pursuant to the significant labor revisions which were implemented over the last couple of years. If the United States believes that Mexico is not effectively rendering enforcement under its labor laws, the rapid response labor mechanism may be expanded to include violations related to any of Mexico's labor laws. So it would not just be limited to the recognition of labor unions pursuant to the freedom of association and right to collective bargaining obligations. So something to be watched for the future. So thank you very much for your time and your consideration. I wanted to present on this topic because my sense is that trade compliance individuals at Mexico facilities may be among the first to become aware of the filing of an allegation, because that initial filing of the allegation would not be a publicly disclosed event. The first notification that a Mexico facility might receive of a violation would be finding out that the goods which have been shipped to the United States, and those entries for the goods that have been shipped to the United States, that liquidation has been suspended on such goods. And immediately after that, the U.S. would refer the matter to raise the matter with the Mexican government authorities, and the Mexican labor authorities would likely initiate a discussion with the facility in Mexico and its corporate parent with respect to the underlying substantive right. So given that this is an area of potential enforcement, we do expect a lot of enforcement activity. We know that a lot of labor unions in all of those priority sectors that were identified at the beginning of the presentation are working to track and identify any examples that they can find of violations of freedom of association or the right to collective bargaining to bring a case. And given the enforcement, that the enforcement really is strictly a trade remedy, suspension of liquidation, loss of preferential duty benefits, imposition of penalties, or even loss of access to the U.S. market, we thought it was important to bring these issues to the attention of trade compliance professionals at Mexican maquiladora facilities. So thank you very much for your time. I've included on the last slide here my contact information. If you have any questions or you wish to share this presentation elsewhere within your organization, please do not hesitate to do so or to reach out. Thank you very much.
John, thank you. Thank you very much for your speech, your presentation, and these important aspects of USMCA that probably most of the trade compliance and foreign trade teams in the maquiladora industry are not fully aware, but to go through the sanctions and possible implications of what you have been exposing now in your presentation is key and is very important, because as we saw clearly, it has an implication with trade trade sanctions, right? And the mechanism of U.S. Customs procedures that we are to be aware, we need to be fully aware. So thank you very much, John,
Thank
to
you for
put this in
having
front
me.
of us. And yeah, your collaboration. Probably not the first time we're going to be talking about enforcement and labor enforcement as well.
Well, happy to assist and participate in any other seminars that you might need.
Thank you very much, John. Thank you again for your participation and collaboration with Index today.
Gracias, Carlos, Samantha, Elvia. Gracias.
Thank you.
Okay. Thank you. Have a nice. Bye.
Bien, hemos escuchado la presentación de John Foote, importantísima, y vamos a continuar resumiendo el tema laboral. Enseguida vamos a tener otra charla por un abogado mexicano que participa como subdirector del Comité Comercio Exterior, perdón, como el subdirector del Comité Laboral en Index. No se la pierdan. Estamos con ustedes enseguida.